Welcome back, focused learners. So today we're diving straight into this explainer on Rule 110 of the Rules of Court. Whether you're a law student staring down a daunting criminal procedure exam, or honestly just someone fascinated by how our legal system actually ticks, Rule 110 is literally the bedrock of how criminal offenses are prosecuted. I mean, this is exactly where the machinery of justice actually starts turning. Here is a quick look at our roadmap for today. We're going to kick things off with a brief introduction, move right into some key concepts, map out the process flow, look at a practical application, discuss exactly why Rule 110 matters, and finally, wrap it all up.
All right, Part 1, Introduction, the Gateway to Criminal Procedure.
So, to really grasp criminal procedure, we first have to understand how this massive legal machinery is triggered into action in the first place, right? You can't just walk up to a judge and casually say someone committed a crime. There's a highly structured gateway. As the Supreme Court brilliantly noted in Tua versus Padillo, crimes aren't just private wrongs. A criminal offense is an outrage against the sovereignty of the state itself. And that's exactly why Rule 110 ensures cases are generally filed in the name of the people of the Philippines. It's not just a petty dispute between two neighbors. It's considered a breach of peace for the people at large.
Moving on to Part 2, Key Concepts, the Tools of the Trade. Let's look at a couple of essential terms from Sections 3 and 4 of Rule 110. You absolutely must commit these to memory if you want to understand how a case kicks off. First up, the complaint. Under Section 3, a complaint is a sworn, written statement charging a person with an offense. The absolute crucial word here is sworn. It has to be under oath. And pay attention to who actually signs or subscribes to it. It's the offended party, any peace officer, or another public officer who's charged with enforcing that specific law, like, say, a customs officer for a customs violation.
On the flip side, under Section 4, we have the information. Now, an information is also an accusation in writing charging someone with an offense, but notice where it comes from. It's subscribed specifically by the prosecutor and filed directly with the court. This is the formal accusation that drops once the state has officially stepped into the ring. There is a really stark contrast here that you need to catch. A complaint is sworn under oath by victims or police, right? But an information is an unsworn written accusation subscribed exclusively by the public prosecutor. You might be wondering, why doesn't the information need an oath? Well, it's because the public prosecutor is already acting under the oath of their office. That little distinction right there is a classic exam question, by the way, so definitely keep that in your back pocket. Okay, Part 3, Process Flow, Stepping Through the Rules. Now that we have our definitions down, let's see how Rule 110 actually puts a criminal case into motion, step by step. This pathway shows the typical journey. Step 1, a crime is committed. Step 2, for major offenses, specifically those penalized by at least 4 years, 2 months, and 1 day, a complaint first goes to the proper officer for a preliminary investigation. They're basically investigating to engender a well-founded belief that a crime was actually committed. And if probable cause is found, boom, we reach Step 3. The prosecutor formally files the information with the court, which officially starts those judicial gears turning. But wait, the prosecutor can't just scribble an accusation on a napkin and hand it to the judge. Section 6 explicitly lays out the sufficiency of complaint or information. If you're prepping for a law exam, you just have to memorize this checklist. The document absolutely must state the name of the accused, the legal designation of the offense, the specific acts or omissions constituting that offense, the name of the offended party, the approximate date, and the place of commission. If any of these material elements are missing, or honestly just fundamentally flawed, the charging document is totally defective. And that could lead to a motion to quash the information before the accused even enters a plea. It's essentially game over before it starts. Next up, Part 4, Practical Application, the theft scenario. Let's ground all this legal theory in a real-world hypothetical to see exactly how Rule 110 operates in action, because theory is great, but application is where it really clicks. Imagine someone steals a laptop from a coffee shop. Sadly, it happens every day. But how do we properly institute this action under the rigid rules we literally just went over? We can't just casually hurl accusations. The information has to specifically align with that Section 6 checklist. Let's map it out together.
The proper party is the people of the Philippines versus John Doe. We have to designate the offense clearly as theft under the revised penal code, detailing the exact act of taking the laptop. The place of commission, let's say a coffee shop in Cebu City, is incredibly vital because it establishes territorial jurisdiction for the court. And finally, it's going to be signed by the prosecuting officer like an assistant city prosecutor. It really have to be this meticulous so the accused is fully 100% informed of the exact nature of the charges against. Which brings us to part 5. Why Rule 110 matters. The stakes of legal procedure.
You might be sitting there wondering why we're so wildly meticulous about these procedural steps. Is it just a bunch of bureaucratic red tape? Absolutely not. Let's look at the immense legal stakes involved. Starting with Section 5, it says, all criminal actions shall be prosecuted under the direction and control of the prosecutor. This matters immensely. While a private prosecutor can intervene for civil liabilities, like getting the victim paid back for that stolen laptop, the state retains ultimate control over the criminal prosecution itself. The prosecutor represents the state's interest to vindicate the rule of law and maintain peace and order, ensuring absolute fairness rather than just facilitating personal vengeance.
Furthermore, Rule 110 fiercely protects the accused through strict rules on changing the charges, which you'll find in Section 14. Let's see how this builds a defense against unfairness. Amending a charge before a plea is relatively easy. The prosecutor can change form or substance without even needing court permission. But substitution? That means you're swapping out the charge for a completely different offense that isn't necessarily included in the first one. That requires dismissing the original case entirely and filing a brand new one. Why? To protect the accused from double jeopardy and to ensure they always know exactly what it is they are defending against. No surprise attacks allowed. When you zoom out and look at these safeguards collectively, Rule 110 isn't just a list of chores. It is the vital machinery that balances the state's immense power to punish with the constitutional rights of the individual. As Section 1 notes, just instituting the action interrupts the period of prescription. It literally hits pause on the legal timer for the statute of limitations. These rules strictly dictate jurisdiction based on where the crime occurred. They guarantee the accused is informed in crystal clear language, and they prevent arbitrary last-minute amendments that would totally prejudice the defense. And finally, Part 6, Conclusion, wrapping up Rule 110. We have covered a lot of ground in this explainer today, from the core definitions of complaints and informations, all the way to the immense constitutional protections embedded in these seemingly dry procedures. So let's recap what you should really take away as you continue your broader study of criminal procedure. I want to leave you with this provocative thought to ponder for your next exam or study session. Jurisdiction is determined solely by the allegations in the complaint or information. It's not determined by what is proven later at trial, or by the actual penalty imposed. It relies entirely on what is alleged on paper on day 1. Think about what that means. A fundamental failure at Step 1 under Rule 1010, say a failure to properly state the acts or the place of commission, could completely unravel the entire judicial process, even after a full trial. That is the incredible, uncompromising power of procedure. Keep focused, keep studying those elements, and we'll see you in the next explainer.